New Colorado employment laws passed in 2023. Update. Colorado has gained a strong reputation as an employee-friendly jurisdiction within the United States. One of the key contributors to this reputation is the Equal Pay for Equal Work Act, which has garnered significant attention, especially due to its wage transparency rules. These rules require employers to include specific compensation and benefits information in job postings, regardless of whether they have a remote employee based in Colorado. I. Ensure Equal Pay for Equal Work Act, EEPEWA, Senate Bill 23105. The EEPEWA, an amendment to the Equal Pay for Equal Work Act, was signed into law on June 5, 2023, and will take effect on January 1, 2024. It expands the investigatory powers of the Colorado Department of Labor and Employment, CDLE, and modifies job posting disclosure requirements for employers. Here are the key provisions. A. Enhanced protective measures by the CDLE. Under the EEPEWA, the CDLE is mandated to create and implement systems to accept and mediate complaints related to sex-based wage equity violations. This amendment makes the protective and investigative measures of the CDLE mandatory rather than discretionary. B. Announcement of job opportunities. The EEPEWA mandates that employers take reasonable steps to ensure all job opportunities are announced to all employees simultaneously and before any selection decisions are made. However, employers located outside Colorado with fewer than 15 remote employees in Colorado are only required to provide notice of remote job opportunities until July 1, 2029. According to the new definitions in the EEPEWA, a job opportunity refers to a current or anticipated vacancy that an employer is considering or interviewing candidates for, or that has been publicly posted. See Enhanced Disclosure Requirements. The EEPEWA introduces new disclosure requirements for job opportunities, including the inclusion of the anticipated closing date of the application window in job opportunity notices. Furthermore, within 30 days of selecting a candidate, employers must make reasonable efforts to disclose specific information about the selected candidate to employees. This includes the candidate's name, former job title, for internal hires, new job title, and information on expressing interest in similar job opportunities in the future. 2. Protecting Opportunities and Workers' Rights, POWR, Act, Senate Bill 23172. This act amends Colorado's anti-discrimination laws, particularly in relation to workplace harassment. Here are the key provisions. A. Expanded definition of harassment and standard of proof. The POWR Act introduces a new definition of harassment that encompasses any unwelcome physical or verbal conduct. Complainants can now select harassment on charge forms or intake mechanism forms related to discriminatory or unfair employment practices. The Act replaces the severe or pervasive standard with a standard that prohibits unwelcome harassment. If an employee establishes harassment by a supervisor, the employer may benefit from an Ellerth-Faragher type affirmative defense by demonstrating prompt and reasonable action in investigating or addressing the alleged harassment, communicating the details of the complaint and investigation process to supervisors and non-supervisors, and proving that the employee unreasonably failed to take advantage of the provided process. B. Amendments to reasonable accommodation and non-disclosure provisions. The POWR Act amends a provision of the Colorado Anti-Discrimination Act, CADA, regarding reasonable accommodation for people with disabilities. The Act removes the previous language stating that employers cannot be held liable for discrimination if the disability significantly impacts the job. The POWR Act also introduces marital status as a protected class in Colorado. It imposes new record-keeping requirements, mandating the maintenance of employment records and complaints related to discriminatory or unfair employment practices. 3. Job Application Fairness Act, JAFA, Senate Bill 23058. The JAFA, signed into law on June 2, 2023, prohibits employers from seeking age-related information, such as date of birth and educational attendance details, on initial job applications. Exceptions are allowed for certain situations, such as verifying compliance with age requirements based on safety, federal laws, or state and local laws related to occupational qualifications. IV. Additional uses for paid sick leave, Senate Bill 23017. Signed on June 2, 2023, SB 23017 expands the acceptable uses of paid sick leave under the Colorado Healthy Families and Workplaces Act, HFWA. The new qualifying reasons include time off for grieving, attending funeral services, handling financial and legal matters after the death of a family member, caring for family members when their school or place of care is closed, or evacuating a place of residence in unexpected situations. Versus expansion of workers' compensation benefits, House Bill 231076. HB 231076 amends the Workers' Compensation Act of Colorado by extending the medical impairment benefits from 12 to 36 weeks. The act is expected to take effect on August 7, 2023, but a referendum petition may result in the need for approval through a general election in November 2024. V. Public Employees Workplace Protection Act, Senate Bill 23111. SB 23111, enacted on June 7, 2023, aims to protect public employees from retaliation. It grants them rights to discuss workplace issues, participate in the political process, and prohibits certain public employers from engaging in discriminatory or retaliatory actions. These new Colorado employment laws introduce significant changes for employers and employees alike. Employers should review their policies and practices to ensure compliance with the amended laws and adapt to the evolving legal landscape. What this means for Colorado employees. These new Colorado labor and employment laws may have a significant impact on workers across the state. Although many of these changes seem like minor technical changes, their impact on workers and particularly plaintiffs with employment law claims may be far larger than the technical changes to existing law. It may take years to see courts and Colorado administrative agencies flesh out rules and regulations around these new laws, but changes will likely begin by the end of summer as some provisions take effect. If you have questions about your rights or potential claims under these laws, talk to a Colorado employment lawyer right away.